Okay, hello everybody. This little lady right here is Jean Drew, and I'm Harmon Drew. This is going out to Radio Land all over the state of Louisiana. It's like
Video Land.
Video Land too, but here's the deal. This is a courtesy of the North Louisiana Criminal Justice Academy. We're doing this because Post is starting the requirement for legal updates every year. Maybe there'll be some agencies that can't send their people to different classes, and Post hopefully is going to show this on their website to help people stay up on the current law. This is October the 16th of 2013, so if you're looking at this and it's 2017, you better get your legal update from somebody else, because this is the fall of 2013. Now, everything on the slides we're going over pertains to the True Blue Drew book. It's a little booklet that Gene and I have been putting out since the early 90s that pertains to law enforcement officers in Louisiana. But even if you don't have a True Blue Drew book available for sale for $50, even if you don't have one, you can follow along the slides, the projector, the PowerPoint without one, or the West book, or the Lexus book, or you can look up the laws on the legislative website. But we're going to give you page numbers as we go relative to the True Blue Drew book. Okay, real quickly, Gene and I, way back in the dark ages, we were rear echelon crime fighters in the DA's office. And I've been a judge for a good while. I'm on the Court of Appeals. She served on the Court of Appeals as a research attorney for 28, 29 years. What we've got in this 276 pages are the things that we've culled out that we feel like is most applicable to law enforcement officers in Louisiana. There are other sources, but the absolute going to the source of what these statutes are, that's the site you need to go to. That is wonderful. www.legis.law.gov. Then on the top left, it'll say laws. Click. You put in Title 14. You put in Section 31. Whoop, there's the current manslaughter statute. On Chapter 1 of the, you look on page 1, on Chapter 1 of the True Blue Drew book, this is the first time we ever did this. We went into interrogations because we've had a couple of cases come up in the Second Circuit that shows me that some folks are still being taught the way to take confessions effectively, as officers were taking confessions in the 70s and 80s and mid-90s. 2004, there was a case that came out that's radically changed how you're supposed to proceed on a custodial interrogation. We're going to tell you how that runs. Chapter 2, still search and seizures. The main two things this book always covers is search and seizure and Title 14. Chapter 2 has two subchapters. The first subchapter is court cases. What we give you is a dozen subjects that'll come up to just about any law enforcement officer on a weekly basis during your duties as a law officer. And we give you each of these dozen situations, and we bring you up to date from the case that started that concept, bringing you all the way up to date to current laws. The deal about this book this year is everything in this book that came out in 2013, whether it's statutes or whether it's court cases, they're going to be shaded. So whatever you see in this book that's shaded, you'll know that's a 2013 deal. Now next year when the new book comes out in August, what's shaded in this book isn't going to be shaded. It's just going to be the new stuff. And we do a completely new book every year. So Chapter 2 is search and seizure. The first subpart is court cases. Second subpart is if Code of Criminal Procedure orders about search, seizure, stop, frisk, arrest, search, institute, arrest, facsimile application for warrants, electronic application for warrants, etc. Chapter 3, we got all of Title 14 for you. Our explanations amongst all the statutes are in boldface print. So if you see something in boldface in this book, that ain't the law. That's just Gene and Harmon talking to you. You can go with it or not go with it. There are a few people in this world that don't agree with my interpretation of stuff, and that's fine. But amongst the statutes, we try to explain these things the best way we know how to explain it. So if you see something in boldface, that's just us explaining something to you. The next chapter is Title 32. We picked out 50 pages of the most common RS-32 offenses you're going to be fooling with as a law enforcement officer. Then we expanded the domestic violence chapter. We doubled it. We have a hearing officer from Monroe named Lisa Trammell Sullivan who helped us with it, and she is probably the state's expert on domestic violence, and she had a large part to do with that. Then we've got some definitions, and we've got some study guides. If you have a nephew who's about to go to a police academy somewhere, anywhere in the state of Louisiana, if you look amongst those study guides on that C part, I think it's chapter 7 on that, chapter 7, that C part. There's an 8-page short summary of the Louisiana Criminal Code, and it'll help anybody going through any police academy in the state of Louisiana. All right, at the end of the book, we combine the indexes. We got the court cases and we've got subject matter. And you can find we try to really work on the index. We've had a pretty poor index sometimes through the years because they always peter out. That's the last thing we do. Our Julys are pretty poor quality of life anyway, trying to input all this stuff. But we really try to get this index accurate for you this year. The keys to the statute, if it's boldface, it's a comment. If it's shaded, it's a 2013 statute. Okay, here's some lawsuits coming to your parish. Anybody who's a corrections officer, you need to focus here. Either look at this big hole or look up here at the projector. Because these statutes that were passed last year, they hadn't any of them filtered through the system to the courts of appeal yet, but trust me, they're coming. There's 2 different pages. Go ahead and look on page 268 and 269, please. These are about a dozen statutes that passed through last year's legislature in 2012, and it's not a crime. What these statutes are, they're rules and regulations, guidelines, things that are mandatory upon you. They particularly apply to corrections. But if you read the language in it, there's language into it about transporting the prisoners, taking them to jail. I'm pretty sure it's going to bleed over into anything you do as a law enforcement officer. This puts you on notice that if you have a female prisoner who's in the 2nd or 3rd trimester, there's certain things you can't do. There's some certain things you absolutely can't do. No electronic restraint belt, no cuffing behind the back. You can still cuff in front. No leg irons and no placing her face down. They've also got this in the statute. You should only use the least restraint necessary. Since the 80s, there was that case of Graham versus Connor. How much force can you use? Well, the answer is only the minimum force necessary to achieve a lawful objective. So I don't have a big problem with that. If one of those 4 things is violated, and Lord help us, I hope nobody has a miscarriage or something, this is a predicate for a lawsuit. Also, the female prisoner who's in the 4th, 5th, 6th, 7th, 8th, or 9th month of pregnancy has a right to be advised about these laws. We have some comments on these 2 pages. You may or may not want to copy these 2 pages to hand to them, but I think you might want to go to the legislative website and just give them the exact laws. Because I worry about you trying to extemporaneously just say, well, here's the basic rights that you have here. Maybe you're going to leave something out. I'd rather just put it in the lady's hands. There's going to be lawsuits waiting to happen. No leg irons. You can't cuff them in the back. You can't prone her out on her tummy. You're supposed to use the least restraint necessary, and no electronic restraint belt. There's no giving this. There's 2 rights to counsel that are provided in the United States of America. One pertains to the 5th Amendment custodial interrogation situation. The second one is broader. It's the 6th Amendment right to counsel that applies to any critical stage of the prosecution. The 6th Amendment right to counsel is triggered at the 72-hour hearing, whether it's on video or whether it's on telephone or whether the subject comes to court or whether the judge goes to the jail. At the moment the judge says, Mr. Smith, you've got a tentative charge of 1st-degree robbery against you. I note you've been in jail for 3 days. You need me to appoint you a lawyer. Yes, I do, Judge. If you don't mind, please appoint me a lawyer. That's when the 6th Amendment attaches. Among other things, at that moment, if you're going to run a lineup, you've got to have the guy's lawyer with him to observe the lineup. Before that date, before that moment that the lawyer was appointed for the 6th Amendment, you could run a lineup without the guy having a lawyer with him. 5th Amendment right to counsel only applies when you actually have the person in custody and he's being interrogated. Now, minor traffic stop. You have seized the driver. You have detained him. He is not free to go. But you don't have to administer Miranda because he is not in custody. In custody is a much more severe version of a seizure or detention. In custody, a reasonable person knows they're going to be facing an extended serious prosecution. You don't have to Mirandize on a minor traffic stop because a reasonable person knows if he's to get on down the road in about 10 or 12 minutes. But if it's a custodial interrogation, you've got to Mirandize. And many officers have been trained through the years that the way you really get the most out of a custodial interrogation is first you just sit down, no Miranda, just sit down and shoot the bull with a guy, talk to him, gradually say, what happened? I wasn't there. Well, yeah, we got some witnesses saying you were there. Well, I might have been there, but I didn't hurt anybody. Well, we got a couple of people saying you did. Talk. Finally, the guy says, okay, A, B, C, D, E. Then the two-stage technique is then you turn on the recorder. Okay, this is Officer Joseph Jeter with the Bossier City Sheriff's Office. I'm here with Henry Smith on the 14th day of October 2012. Mr. Smith, you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to having a lawyer with you. You can have a lawyer with you while I question you here. And if you can't afford a lawyer, one will be appointed to you by the court. If you want to go ahead and give up these rights and answer my questions, you can stop answering questions anytime you want. The problem with that is the guy says, okay, and then he says, this is 3 minutes after he just said A, B, C, D, E. Then if he says A, B, C, D, E, in this Missouri versus Siebert, the U.S. Supreme Court said, before you even get to all the Miranda stuff, the custodial interrogation has to be free and voluntary, and if somebody was cajoled, talked, spoken to, going back and forth, and finally fessed up to A, B, C, D, and E, how in the world is he going to say anything different 2.5 minutes later after he's been Mirandized and the recorder is running? There's a two-stage interrogation. Talk, no Miranda. She finally says, yeah, that's how it went. Mirandized on the recorder, and then she confesses. The U.S. Supreme Court threw it out saying that wasn't voluntary. There's two ways you can go on this deal. One is you do audio and video of everything. That was my original position way back in the late 80s when I started teaching at the Bellevue Academy. I said, why are you making this judge trying to believe you and not believe this other person about exactly what happened when you had a recorder and now you got a video, yet you chose not to record any of that? So it just doesn't seem to pass the sniff test. And then Richard, the officer I'm talking about, would say, well, you're not going to get anything out of him like this. The best way to do it is get his line out of the way, and then you get him to give a statement. Well, if you want to do it like that, you apparently can still do it, but here's what you need to do. The big word of the day is attenuate. Whatever happened before, it needs to be attenuated from the actual statement that's given. In other words, if you have a non-Mirandized statement that is made, you need to have a break. Get him a hamburger. Let him have a drink of a cup of coffee. Let him go to another interrogation room and be interrogated by another police officer. All those are possibilities, but you got to do it one way or the other. Either do a video and audio of every second that you're with this person, or if you're just going to start at a particular point in the situation and get the Miranda warnings on the recorder, on the video and stuff, you need to make sure there's a big break in between the initial conversation, which you'll never get into evidence, and the later conversation that's Mirandized. And they suggest another room, the passage of time, and maybe even another officer doing the interrogating on the deal. On the Florida versus Powell, good case saying if you're going to explain Miranda, there's not one specific way that you need to do it. I've had officers that say, I read him his rights. Some of y'all are pretty good readers, some of you aren't, and I know that for a fact. But if somebody who just reads through the rights real quickly and say, sign here, you're not supposed to read them the rights, you're supposed to explain them the rights. Since I know everything, I told law enforcement officers for 20 years, well, the main thing you need to know on a custodial interrogation to make sure they understand their right. Miranda warnings is, you need to find out if they've got a high school diploma. That'll tell you if they got some smarts or not. Well, imagine my surprise 5 or 6 years ago when somebody said, dummy, the high school valedictorian gets the same diploma that the special ed kid does. Just having a high school diploma doesn't mean they got a whole bunch of smarts. So your responsibility is to try to ascertain whether this guy's understanding what you're talking about. And I hate using words like, do you want to waive these rights? What do people know about waive? Do you want to give up these rights? You have to explain it to them. That's what this Florida versus Powell case is saying. There's not one way to do it, but they've got to understand it. State versus Shirley is a great case. It happened down there in Bossier Parish in Louisiana. There was a car wreck. The lady ran through a stop sign. Her guest passenger was killed. She had been drinking. The officers talked to her at the scene. She said, yeah, I was drinking, had a couple of beers and Smirnoff, but I don't think I was under the influence or anything because that was a while back. They kept talking at the scene. Well, what did happen? Here, let's look over here. Never was she arrested. Never was she placed in a situation that's tantamount to an arrest. Never was she handcuffed. Never was she taken from a public to a private area, like putting in the back of a unit. A reasonable person would have thought they could have ended this encounter. A reasonable person would have known they were not in custody for purposes of Miranda right there. Because Miranda doesn't trigger in until there is someone actually in custody who is being interrogated. On this case here of State versus Shirley, the big deal was not handcuffing her, not taking her from a public to a private area, and not saying you're under arrest, and not treating her as if she were under arrest. So she incriminated herself in many different ways, and all of that was allowed into evidence. Another drinking-related case is if the subject is under the influence, under this Thornton case here, Louisiana Supreme Court, you can still question them. You don't have an element of suppression of your comments with this person. If he's not in custody, you don't have to Mirandize the guy. But the deal is, even if he's impaired, the only way you're going to get into a suppression issue is if there's some kind of coercion involved. If the person is voluntarily talking to you, it's okay they've had several beers or whatever. The Sixth Amendment was implemented by the language of the Sixth Amendment about the critical stages of the proceedings. The Fifth Amendment, the only way that was triggered was through the Miranda case. But if you look at that comparison graph on page 8, it'll help you explain these two rights to counsel. So whether you were getting him out of the car to arrest him or getting him out of the car for officer safety, you were going to see the heroin and cocaine on the seat. You were going to see it anyway, so you're going to be good to go. In other words, there's a safety net underneath what you're doing that wasn't there 15 years ago. It certainly wasn't there 30 years ago. Because back in the day, the deal was, under what theory were you operating? And if you guessed wrong on that, the evidence was going to probably be suppressed. Now is, what'd you do? It's interesting to know what theory you might have been proceeding under, but the courts can make the decision about whether there's a lawful way to justify exactly what the law enforcement officers did. It's a real comfort. Likewise, if you make an arrest, man, you need to have probable cause on that crime. You know that. If you don't, though, have probable cause to make an arrest on crime A, it's probably not going to be any civil liability as long as you had probable cause to make an arrest on crime B. It doesn't really matter why you did something. The question is, what you did, is there a lawful justification for what you did? Here's the problem. Before 1967, everything on search and seizure pertained to trespass. Trespass is a common law term. It never really fit. It never adequately was juxtaposed in the Louisiana law because we're a civil law state. That all these theories of trespass. To what extent are we going to protect the suitcase, the home, the handbag, the pocket, the FedEx envelope? All these different rules about trespass. Starting in 1967, the case you learned in the academy, and the case we just went over, Katz's case, K-A-T-Z, that's the one it's about illegal wiretaps, but the reality of that case is the court said we're going to protect whatever somebody wants to be protected as long as society as a whole is willing to recognize it, willing to justify it. Somebody like Howard Hughes wanted all kinds of privacy that society wasn't willing to recognize. But the general deal is you don't look at particular containers and what's the level of protection here, there, and yonder. What you look at is just the overall deal. What did the subject want kept private, and was that a reasonable expectation on his part? That was in 67. 45 years later, trespass is raising its head again on two different cases. Reasonable expectation of privacy is still the deal, but in addition, there are trespass considerations. First of all, on terminology, nobody knows how to quantify these different terms. Gene and I, we've read I don't know how many cases saying it's really impossible to quantify reasonable suspicion and probable cause. Accordingly, we spend a lot of our adult life trying to quantify reasonable suspicion and probable cause. We suggest having reasonable suspicion means you're 25 or 30% possibility that what you think is happening is happening. Probable cause, we think you got to bump it over 50%. Different people have different ideas about this. I mean, we don't have the exclusive on this deal, but we think that reasonable suspicions, about 25 or 30% sure. PC, 51% sure. Proof beyond a reasonable doubt, 95% sure. Another way to look at it is if you take reasonable suspicion and you double it, and then you have PC, then you double that, you got proof beyond a reasonable doubt. These phantom percentages, the way they come about is what's your knowledge, training, experience? Then the second deal is what did you see, smell, hear, feel, touch, taste? You combine these two things. And like these young Peckerwoods here, they're going to get out of the academy in a few weeks. They're going to have to observe a whole lot more than you are to get to a situation where you've got reasonable suspicion or probable cause. If you've been on the road for 25 years, you're going to get to reasonable suspicion or probable cause a whole lot quicker than these cadets are going to be able to get there. But it's all relative. The more knowledge, training, experience, the less observations are required to satisfy these different burdens right here. The detailed reports will assist you very much on this. I would think that having to do detailed reports could be a drag for some of y'all, and I understand that. There's a very good reason that's in your best interest to have very detailed reports. One, if there's a pretty important factor that you don't remember till you get to the motion to suppress 8 months later, the criminal defense lawyer will say to you, well, if you are remembering that earth-shaking deal today, why didn't you put that in your report? That diminishes your credibility somewhat. The second deal, evidence doesn't get suppressed in 2013 nearly to the extent that it did in the late 70s and the 80s. It's nowhere close. But I really believe that a pretty large percentage of the time, the reason that the evidence gets suppressed is sometimes maybe a prosecutor doesn't ask the right questions. Questions will be, hopefully, they'll be easier for prosecutors to get to asking the right questions if there's a detailed report. I ain't talking about any one DA's office anywhere, but it's one hand washes the other. The legislature makes the law, y'all try to enforce it, and the judge try to interpret it, but everybody needs to sort of help each other. But the more detailed the report, the better. Example, if we had a case where the officer said, well, I searched this abandoned house, there's no privacy interest in an abandoned house, and I found the contraband in there. Matter of fact, I found the two guys with the contraband and the stolen items. The Louisiana Supreme Court suppressed the evidence, said, just making a conclusion that it's an abandoned property, you ain't really said a whole lot. Tell me why you came to that conclusion. I guarantee if that assistant DA had said, well, why'd you think it was abandoned? Well, the weeds were up 6 foot high, the windows were knocked out, the door was boarded up. It wouldn't have taken but a couple of questions, but if the question isn't asked, then it never gets in there. Now here in Bossier-Webster, your judges know you. I guarantee they know you, and they know that you may have a reputation for telling it exactly like it is, or maybe there's a sort of little that old sinking feeling about your testimony. Just know this, if you ever try to cut a corner, that's the toothpaste that you can't get back in the tube. You can't ever get it back there. Whatever happened, happened. But another example, if you have simple battery and add to it any one of the 5 elements of serious bodily injury, it bumps up to a 5-year felony of second-degree battery. Louisiana Supreme Court 5 years ago had a case that came up to them on second-degree battery of felony prosecution, and the only testimony was there's a lot of blood loss. Well, more than likely, if that prosecutor had said, well, did it hurt? Oh, yeah, it hurt. Or the prosecutor said, well, you got any scars from that? Oh, yeah, see this? Terrible scar. But the question was never asked. And like, when you hear terms like inflict great bodily harm is common sense. On the felony type of battery of an officer, did the injury require medical attention? That's common sense. But on that phrase, serious bodily injury, that ain't common sense. That's a statutory definition. In every statute that utilizes that phrase, you need to look down in the C part or the D part, and it'll say for purposes of this statute, quote, serious bodily injury, unquote, shall be defined as. And usually, now underline that word, usually, that's a painful word. Usually, you got 5 different ways you can prove serious bodily injury. Extreme pain, disfigurement, impairment or loss of an organ or a mental faculty, unconsciousness, or near-death experience. Unfortunately, some of the types of ways you can prove serious bodily injury leaves out extreme pain, such as implied consent. Other types of serious bodily injury leaves out unconsciousness. Accordingly, you need to make sure if you're utilizing that factor of serious bodily injury, you need to make sure for the purposes of that statute that the elements you're proceeding on exist for that statute. But good reports will cover you because it'll help your credibility, it'll help your DA screen the case, and it'll help your DA to ask the right questions. Again, we think if you get reasonable suspicion and double it, you got PC, you double that, you got proof beyond a reasonable doubt. And if you ask any 10 people, they may or may not agree with that. Stop and frisk, no big deal has changed about that. What's changed about it is the Louisiana statute that implements Terry versus Ohio in Louisiana. Terry versus Ohio, that's the first case you learned in the academy. With reasonable suspicion of criminal activity, you can detain someone. With reasonable suspicion of danger as to that guy, you can frisk him. You touch something hard that may be a weapon, you have the right to get it out. More than just once you do a pat down and your fingers touch something hard, virtually anything hard can be a dangerous weapon. Dangerous weapon, any instrumentality which, in the way and manner that it's used, is it calculated or likely to produce death or great bodily harm. You get out something hard, it may be a weapon, you're good to go. You touch something that feels green to you and vegetably, instead of just getting it out, you may have enough knowledge, training, experience to have PC to get out the marijuana. But, Gene, I used to tell y'all to ask 3 questions. I'm great at this now. 4 questions. Sir, you got any weapons or drugs on you? Question mark. Number 2, would you mind emptying your pockets on the hood of my car? Question mark. Number 3, sir, you missed something, didn't you? Question mark. Sir, would you mind taking that cocaine and putting it on the hood of my car? Question mark. If you ask 4 questions, and I told y'all last year, I think, if the subject is Hispanic, you got to do it upside down, question mark. But anyway, if you ask the questions and they comply with your request, that's not even a search. That's not a Fourth Amendment deal. That's a plain view seizure is all it is. The burden's on you to show that it's voluntary. But if you touch something that you think is contraband, you got to have twice the burden satisfied to get it out without his consent. Then if you touch something hard, it may be a weapon. Here's the problem. If you go to page 37 real quickly, look at the bottom of the page. Please would be nice. I know a lot of y'all are packing heat, so please, if I don't say please, you may assume I mean that. You've got Code of Criminal Procedure Article 215.1 at the bottom of the page. A, B, and C, that's Terry. A part, with reasonable suspicion of criminal activity, you can detain. B part, reasonable suspicion of danger, you can frisk. C part, reasonable suspicion you've touched a weapon, you can get it out. The D part is about traffic stops. And it's saying, officer, you want to make a traffic stop, get after it. That ain't real hard. In other words, if you come in at the end of the shift saying, I made a traffic stop today. Well, guess what? You follow somebody 150 yards in the state of Louisiana, you've got to pick amongst the half dozen traffic infractions you've just observed. It's in the water supply. That's just, you're going to see some traffic violations. Back in the day, it was difficult to make traffic stops, but easy to extend. What that D part is telling you on that page is, you want to make a traffic stop? That's not difficult. The only question on the traffic stop is, did you observe the infraction? But the clock's running. And I'm a podunk. I live in a podunk area, but even the most podunk law enforcement agency in the state of Louisiana is going to be ascertainable after the fact, the minute at least, if not the second, that the stop occurred. And if you made a traffic stop at 2:15 in the morning, but didn't develop probable cause until 3:15, or didn't get consent until 3:15, somebody, probably the judge, is going to know where that other 45 minutes go. Gene and I feel pretty comfortable that if you make a regular traffic stop, you've bought yourself 10 or 12 minutes with a person. What can you do? Well, if it is your practice or your agency's policy, if you have a safety way you handle this, you can get them out of the car. What has to happen to trigger your right to get them out of the car? Not a swinging thing, except you're dealing with a subject who's in a car. You have the right to see the hands. A minority of agencies in Louisiana, some of them that we teach have gone back to making them stay in the car, but keep the hands on the steering wheel. Whichever one you want them to do, you have the right to insist that they do that. Why? Officer safety. Once you do that, what can you do during a regular traffic stop? Well, you can check the registration, proof of insurance, driver's license, run the computer, issue the citation, and it's adios unless during that traffic stop additional reasonable suspicion of criminal activity is developed. Was the guy getting more and more nervous? Was he getting more and more belligerent? Was he answering questions you weren't asking him? Was he wearing an overcoat in July? Was he trying to reach in his pocket? Was he trying to get it back in the car? Whatever happened, happened. But it's like maybe you made a stop at 2:15 and the guy was uncooperative. Maybe there were several people in the car, you wanted to process one at a time. You're not going to ever get more people out of the car than there are officers that are standing there. Maybe the computers were down. But I just think as a rule of thumb, if you get a traffic stop that lasts more than 10 or 12 minutes, you better be making a list of the other factors that occurred that led you to think that additional reasonable suspicion of criminal activity was developing. Reasonable suspicion of criminal activity, stop them. Reasonable suspicion of danger, frisk him. Reasonable suspicion that he's actually got a weapon, you can get the weapon out. Here are the two trespass considerations. And this, I don't think this is a great development for law enforcement, but as it is right now, it's just a couple of cases. We'll see in a few years where it's going. You might remember on our annual updates, I assured you for 2 or 3 years in a row that this case about the GPS being attached to the exterior of a motor vehicle, I assured you that it was going to go in favor of law enforcement 9-0. The reason I assured you of that, we've got case after case through the years saying there's no privacy, there's no valid consideration of privacy on the exterior of a motor vehicle knowingly shown to the public in a public area. There have been cases where in hit and runs they scrape blood and paint, hair off cars that were in public. Well, guess what? I was wrong. And I wasn't just sort of wrong, I was 9-0 wrong. The U.S. Supreme Court said if you're going to attach a GPS to the exterior of a motor vehicle and or if you're going to monitor it, that's a search. The importance of that is any search or seizure in Louisiana that's done without a warrant is presumptively unreasonable. They didn't exactly say you had to have a search warrant, but I'm telling you that's the reality in Louisiana. And the thing that's sort of frustrating about it, attaching that GPS and then monitoring it is not doing anything that 25 or 30 of y'all couldn't do, but at a much, much, much lesser expense. Nonetheless, the 5 of them on the U.S. Supreme Court said that's a trespass. We never said in the Katz case in 67 that trespass wasn't to be considered anymore. We just added the reasonable expectation of privacy. So since that was a trespass, we're going to say that that's a search, and in order for you to search without a warrant, that's going to be presumptively unreasonable. Terrible facts in the Jones case. They got a search warrant in D.C. and they attached the GPS in Maryland. They got a search warrant that was good for 10 days and they attached the GPS on the 11th day. About everything that could go wrong went wrong. Nonetheless, 5 of them on the Supreme Court said, no, this is no good. It's a violation of the right of it's a trespass. The other 4 said, well, really, it's just reasonable expectation of privacy. Whatever it is, just know there's a new consideration carved out in addition to reasonable expectation of privacy, and that's trespass. One of them applies to a GPS attached to the exterior of a motor vehicle. The other one just came out this spring, and it's the Jardines case that came out. It's where a canine officer approached the door of a home and told Fido to do his thing, and Fido alerted. Can you go up somebody's front door? Yeah, you can walk on the sidewalk, walk up the front walk, knock on the door. What's going on? I'm Officer Smith. I'm here to win the hearts and minds of the people. Do you mind if I come in? You seen any criminality? Nothing wrong with that. The U.S. Supreme Court said bringing a dog up to the front door and the dog alerting, and then that becomes your PC for a search warrant, that's a trespass. They analogized it in the U.S. Supreme Court to going up to one of the side windows and looking in the window. They said this is not reasonable. We're going to suggest to you 2 things, and for what it's worth, everybody knows the 4th Amendment is the basic search and seizure. You got to have people are protected from unreasonable search and seizure. In order to secure a warrant, you got to have probable cause. There are 2 other deals that we need to think about. If you see something out of the Louisiana Supreme Court, you don't see it that often anymore. Back in the day, if something didn't have pass the sniff test, a lot of times you'd see right of privacy because we specifically have that in the Louisiana Constitution. So that's still a consideration for the Louisiana Supreme Court, and it's roughly analogous to the U.S. Supreme Court using this right of trespass. All right, let's talk about motor vehicles. What parts of the cars can you get into, and what could you look for? Back in the 20s, the Carroll case, you learned that. The officers developed probable cause that this vehicle contained bootleg whiskey, and they were in the Detroit area, and they knew if they took the 3 or 4 hours it's going to take to get a search warrant. This wagon's going to be across into Canada before they could do something. So that's in the 20s where the Carroll doctrine came about. If you have probable cause to believe that a movable vehicle in a public area contains contraband, you get the car. You get every inch of the car. That's the Carroll case, and nothing really has changed about that now. When you have PC of a motor vehicle, you get the entire car. Inventory, you get the entire car, but we got us an asterisk there. Inventory, the reason you inventory is for valuables, trying to protect the person's valuables, and in turn to protect your agency against civil suit. The question is, well, if you inventory, can you get into closed containers? That answer is yes, if your chief of police or if your sheriff has a written policy. All it's got to say is, henceforth, officers of the Bossier Parish Sheriff's Department, when inventorying motor vehicles, shall inventory the contents of closed containers. That's all it takes, but it's got to be something in writing. You've got one here. The name of the case is Florida versus Wells, and that's been the law in 1990. I know for a fact in a lot of jurisdictions they don't have it. You can still inventory the contents of the vehicle, but if you don't have a written policy, there's going to be a problem about you getting into containers. And that's where a lot of the bad stuff is going to be. It's going to be inside of the containers. Now, the inventory, the reason you inventory is not for criminality. It's an administrative search. And it's trying to keep civil suits down against your agency if Aunt Jean's pearls come up missing or something gets broken in the car. It's an inventory. However, if you have a lawful right to be where you are and you come across something that's immediately apparent to you to be contraband, you got the right to seize it. Did you have a lawful right to be where you are? Did you immediately know it's contraband? Was there some kind of protected area that this stuff is in? No, get it. But the reason you're in a vehicle for an inventory is to make a listing of the valuables. Consent. Got an asterisk about that. You got the whole car for consent. If the only way you're in a motor vehicle is by consent and they withdraw their consent, that's the end of it. If that's the only way you're in. We think, even if you think you got PC for this vehicle, or even if you think you've made a valid arrest and you've got reasonable beliefs that evidence of the crime rests in the car, therefore you get the passenger compartment under the legal theorem of searching, instituting arrest, we always think you ought to ask consent. Because then if they consent and you were wrong about your PC or wrong about your right to search, institute, and arrest, you got consent. The only thing negative that we can come up with that maybe would happen would be the criminal defense lawyer say, well, you say you had probable cause to search this vehicle. Yes, I did. Well, if you had probable cause, why'd you ask for consent? Your answer is, we try to do things the easy way up here. We try to keep everybody calm, relaxed. I asked for consent. He said, no, not going to let you do it. Well, sir, I've got the lawful right to do it. Accordingly, I'm going to get you over here. If you have the right to consent given and you were wrong about your PC or your SITA, you're still going to be good to go. But on consent, the question comes up through the years, can you get in a closed container if you have consent for the car? The name of the case is Florida versus Jimeno. And the answer is, yes, you can get in a closed container, but you've got to check off 3 blocks. Number 1, did you reasonably think you had consent for the container as well as the car? Number 2, could you get in the container without damaging or destroying it? Number 3, what you're looking for, could it fit in the container? If you can answer those 3 questions yes, the consent for the car is good for the containers. Now, if somebody says, I'll give you consent to search my car, but I don't want you in the trunk. I got some stuff there for my grandkids. I don't want you back there. If the only way you're in that car is by consent, you've got to comply with the restrictions that are given to you. Now, frisking and SITA, you can get in a passenger compartment. You're saying frisking a vehicle? Well, yeah, you got the right to frisk a vehicle, but you got to check off 3 blocks there. The name of the case is Michigan versus Long. You have the right to run a brief frisk of the passenger compartment under Michigan versus Long. It's been the law for 30 years. Louisiana Supreme Court, U.S. Supreme Court, as of this date, are precisely on the same page, search and seizure-wise. You can get in the car for a brief frisk for weapons if, number 1, have you already frisked somebody? Number 2, is that person about to get back in the car? Number 3, do you still have a reasonable suspicion of danger? Now, remember, you can get them out of the car automatically, but you can't frisk them unless you develop a reasonable suspicion of danger as to that person. But if you have already frisked him and he's about to get back in the car and you still got a reasonable suspicion of danger, before he sits down in the car and reaches on the seat and gets something to hurt you with, you've got the right to make a brief, quick frisk of that passenger compartment. I hadn't had a bunch of cases on that, but there have been some cases about that. But you've got to get that established. What I don't have a good way for you to do that, I don't have a good way for you to frisk the passenger compartment if it's just you and him. If you've got backup there, you can ask him to stand over here with the other officer and do that. But if it's just you and him, you've got some hard decisions about how to proceed on that. But a frisk is just going to give you the passenger compartment. Where can he quickly grab something that could hurt you with? The reason you're in the passenger compartment on a frisk is for officer safety. However, if you have a lawful right to be where you are, there's very low privacy interest in the passenger compartment of an automobile, you see something that's immediately apparent to you to be contraband, you have the right to get it out. Same on the SITA. Well, the good old days in 1981, the Belton case said, you make an arrest of somebody who's an occupant of a motor vehicle, you get the passenger compartment automatically for weapons or for evidence, and you also get any closed containers. Now, you just get the passenger compartment. Under SITA, you don't get the trunk, you don't get the wheel covers, you don't get the motor, but you get the passenger compartment. That was an automatic deal that was going on all over the United States, but not in Louisiana. That was the law in Louisiana. 26 years later, in a case that's now moot, that became the law in Louisiana. Then 22 months later, in the case of Arizona versus Gant in April of 2009, the U.S. Supreme Court said, realistically, the only way you're going to get into that car under the concept of searching instituting an arrest is if you have reasonable belief that evidence of whatever you made the arrest was in the car. SITA is, whereas a frisk is a brief looking in the passenger compartment for something that might be an evidence, search instituting an arrest could be more extended. You get the passenger compartment for weapons or evidence, and you also get the closed containers right there. Realistically, there hadn't been but one case that I know of, and I was on the panel that wrote it. It's a case called State versus Cook out of Monroe. It said on the DWI of any genre, of any type crime that's going to, more than likely, you're going to have reasonable belief that evidence of the crime of arrest in the car, yeah, it's going to be DWI. Because if you have probable cause to believe that this guy is impaired operating a motor vehicle, certainly you've got a reasonable suspicion that there's going to be beer bottles and beer cans of drugs in the car. So real quickly, running over these cases. Carroll case. You got PC for a movable vehicle in a public area, you get the entire car, stem to stern. In Opperman case, that's your opportunity to get in the car. The reason you're in the car is an administrative reason. You're in the car to try to make a list of the valuables to protect his property and in turn to protect your agency against civil suit. The important thing is on that Florida versus Wales case that there be a written inventory policy about closed containers. Then consent, your assumption is going to be that you got consent for the entire motor vehicle. But the only way you're going to for sure get in the containers, now you may have it on your consent form. You have the right to search my 2012 Toyota Corolla and any containers therein. That would be great. But it's like the only way you're going to be able to ascertain for sure that you've got a right to search the closed containers on just a consent basis is, did you reasonably think you had consent for the containers as well as the car? Could you get in the container without damaging or destroying it? And what you're looking for, would it fit in the container? U.S. versus Cotton is just like the opposite of Jimeno. In U.S. versus Cotton, it's a Texas case, but it's federal Fifth Circuit that applies to y'all. But on the Cotton case, all the subject gave the permission for was to search a container, yet the officer searched the entire car under consent, and the U.S. Fifth Circuit said no. If all you have is consent for the container, that's all you got. If you get consent for the whole car, if you can check off those three question marks, you might have consent for the closed containers. A frisk, that's Michigan versus Long. It's a quick search for weapons for officer safety. And the Belton case was implemented in Louisiana in 2007, but now it's pretty much out the door, except to this extent. Cadets, Belton is still good for purposes of where you can search and what you're looking for. Belton is good because in the SITA of a motor vehicle, the rule still is you get the passenger compartment, any containers therein, and you're looking for weapons or evidence. The restriction on it is what happened in April of 2009 on the Gant case. The only realistic way you're going to get into that car, strictly under the legal theory of searching instant to an arrest, is if you have a reasonable belief, which is the same thing as reasonable suspicion, that evidence of the crime of arrest is going to be in the car. And like I say, the State versus Cook, it's just a Second Circuit case. It's the northern 20 parishes in the state. But on the Cook case, we say there that of any type of crime, DWI is going, if you got PC for that, you probably got reasonable belief that evidence of that crime is in the car. Rawlins versus Kentucky came about in 1980, and those of you who came through the police academy, say through Bellevue back in the dark ages, I never taught you Rawlins versus Kentucky because that wasn't the law in Louisiana. What Rawlins versus Kentucky said in 1980 was, you got PC to arrest this person, your SITA of this person has to be substantially contemporaneous to the arrest, but it can be immediately before, during, or immediately after the arrest. That never was the law in Louisiana. Fast forward from 1980 to 2006, and now that is the law in Louisiana. The name of the case is State versus Sherman. It's out of Alexandria, and that's the Louisiana Supreme Court case. And what the deal is now on searching instant to an arrest is, you don't have to make a lawful custodial arrest. You don't have to intend to make an arrest. You might later issue a citation, or you might later just say, have a nice day. The only question about whether you can conduct a search incident to an arrest is, do you have probable cause, and is it a crime which allows an arrest? If so, you can proceed, you can always arrest him, and then search him instant to an arrest. I don't know a good way to unarrest somebody, so the other thing you could do is, well, you had reasonable suspicion of criminal activity to stop him, something happened, gave you PC to make an arrest. Let's forget the arrest right now. You got the right to search him instant to an arrest for weapons or evidence. Then you can make a decision on whether you want to arrest him or not. Okay, look at this big hole right here. If you search somebody instant to an arrest before you actually arrest them, and you find heroin in his pocket, you need to make the arrest not only for possession of heroin, but you need to make the arrest for whatever crime you originally had PC for that enabled you to search instant to an arrest. It's just like on a pretextual traffic stop. Before 1996, if the state trooper took the stand at the motion to suppress, said, yeah, he was changing lanes without signaling, but the reason I stopped him, actually I heard he was a fence and he was dealing in stolen property, and I was trying to develop some interaction with him. Maybe develop PC to get in the car, or maybe get consent to get in the car. Before 96, that evidence was 100% of the time suppressed, and anything that came from that. Now, however, the only question on the traffic stop is, did you observe an infraction? So the stop's good. There is such an animal now since 1996 as a good pretextual stop. There was no such thing as a good pretextual stop before 1996. Name of the case is WHREN, the Wren case. And there's been tons and tons of Louisiana Supreme Court cases adopting that. So if you want to make a traffic stop, that's pretty easy. If you develop probable cause to make an arrest, you got to make sure it's a crime that allows an arrest. In all of Title 14, Gene and I can't find but one crime that does not allow an arrest, and that's 93.12, a kid under 21 in public possession of alcohol. That's a required citation. Now, you can always, well, I've developed probable cause to arrest, therefore I'm going to search him instant to an arrest. You don't find anything? Have a nice day. You don't find anything? Maybe issue him a citation for that original charge. But what you can't do is issue the citation and then search him instant to an arrest. Once you've issued the citation, you're totally out of the SITA situation. Once you've issued the citation, you've got a situation that's in effect a summons or a citation that ain't an arrest situation. You could have arrested before, and therefore you could have searched instant arrest, but if you issue the citation, there is no more search instant arrest. The Rawlins case was in 1980. A quick 26 years later, that became the law in Louisiana, and the only criteria is, do you have probable cause to make an arrest, and is it a crime that allows an arrest? The Green case just said the same exact thing that these other cases said. Doesn't matter if the SITA, the search instant to an arrest, is conducted immediately before, during, or immediately after the arrest, or even now in lieu of the arrest. On these situations here, State versus Green follows State versus Sherman and follows Rawlins versus Kentucky. Is it going to take a good report? Why, certainly it will take a good report. But I don't know of a good way to unarrest somebody. So instead of going through the arrest procedure, you can just search into an arrest if it's a crime that allows an arrest and you got PC, and then you can decide whether you want to arrest him on the original charge or not. Of all the factors involving whether or not you're making you had reasonable suspicion of criminal activity to make a stop. The largest factor by far is unprovoked flight from a clearly identifiable law enforcement officers. We've got some situations come up about using handcuffs. Trust me on this, before 2003, if you utilized handcuffs, you'd answer the question about whether you'd arrested somebody or not. Since 2003, Gene's going to real quickly tell you about 4 cases that have come up from Louisiana Supreme Court that said in certain situations it is acceptable to use handcuffs before, even though you don't have probable cause to make an arrest. Is this a grown-up type decision? Oh, it absolutely is. Because if your judge is trying to decide whether you got this guy in an arrest situation that requires probable cause, or whether you just got him in a brief detention situation that only requires reasonable suspicion of criminal activity, the first item on the list is going to be whether or not you used handcuffs. I hope you don't have to cross this Rubicon right here. But these 4 cases said in certain situations, and each of them talk about maintaining the status quo for officer safety. But again, you better have a good report if you do this. Gene's going to tell you about these 4 cases real quickly.
And these are on page 14 and 15 of the True Blue Drew book, if you want to look there about the little summaries of the case. In State v. Adams, a couple of male officers in New Orleans saw a woman running from them to try to hide. She was fooling with her waistband. They detained her, and they called for a female officer to come to do a thorough frisk of Adams. While they waited for the officer to get there, she was cuffed and placed in the patrol unit. The court said that that was appropriate because they were in an area where there were a lot of pedestrians moving around. There'd been a lot of drug activity in that area, and it was appropriate for officer safety. In Bossier, some officers in Jefferson Parish went out to investigate a burglary call. When they got into the apartment that was supposed to have been burglarized, they didn't find a burglar but found a whole lot of money and drugs in plain view. When they started investigating the drug situation, Bossier came walking up, tried to leave, but he was detained, asked his name, and he was cuffed. He was asked for identification, and he told the officers he had some in his apartment upstairs. He gave permission for them to go upstairs with him, where the officers found drugs in his apartment, and he was also prosecuted. In that case, the cuffing of Bossier was held to be appropriate because the officers were in a rapidly evolving and potentially dangerous situation and needed to make sure that they were safe while they conducted their investigation. Palmer involved a case in Natchitoches where officers went out on a complaint about drug being dealt from a residence. When they got there, a whole lot of people were in the house who tried to flee. The officers gathered up all the runners and had them together in the yard. There were a lot more people there than there were officers. They cuffed those people while other officers conducted a search by virtue of a consent from an occupant in the house. That was also held to be appropriate. In that case, the court said just because you're investigating a drug case does not mean you can automatically cuff somebody who's been detained during your investigation. The court is going to examine the facts and circumstances in each particular case to find out if the officers were reasonable in doing that. And all of the factors were officer safety, maintaining the situation, keeping stability in the situation. And Thompson is another case out of Shreveport involving execution of drug search warrants at the Livingston Motel. I don't know if any of you all are familiar with that place, but it is, sort of a particularly high crime area in Shreveport. Thompson was nearby the rooms that were being searched. He was detained and cuffed and ended up being prosecuted for his own drug violations. And the court again said it was appropriate for officer safety, high crime area, and more people around than there were law officers.
On these 4 cases, Adams in New Orleans, Bossier in Jefferson Parish, Palmer in Natchitoches, and in the Thompson case in Shreveport, the commonality factors were they weren't all at night, but 3 of the 4 were at night. There were more subjects than law enforcement officers, and each of the cases say almost specifically the same phrasing. The officers were objectively reasonable in maintaining the status quo for officer safety. But it isn't something that is going to be a normal, everyday occasion here, and that's still a huge decision to make, the decision to cuff somebody without having probable cause to make an arrest. And again, that gets you way down the road where a judge is going to expect that you need to be able to demonstrate you already had probable cause before you use the handcuffs. All we're saying is before 2003, you had already answered the question by virtue of the fact that you handcuffed somebody. You had arrested him. You were going to have to demonstrate at the motion to suppress that you already had PC to make the arrest. Now there may be certain exceptions when that's not going to be required. Usually it's going to be at night, more subjects than law enforcement officer, and usually it's going to be just a brief situation in a high crime area. Just in summary, as recently as before 1996, the early 90s and the 80s and the 70s, it was sort of difficult to make traffic stops. A lot of DAs wouldn't take cases unless there were at least a couple of bobbles, but it was easy to extend. Now just the opposite is true. It's easy to make stops, but that 215.1 in the book talking about the D part of that statute, talking about how the clock's running, all you can do on a traffic stop is what is involved in that traffic stop unless reasonable suspicion of criminal activity occurs that leads you to be justified in extending the stop. On page 37, the bottom half, that D part, you need to read that, and just the reality is everybody's going to know the exact minute that the traffic stop was made. That's probably the biggest case in the last 10 years for law enforcement officers in Louisiana. It's an ultimate search and seizure case, and it comes out with 3 different findings that I think are very important. Gene, just quickly run over certain. We're losing time here.
Okay, in Certain, 2 officers were observing in a high crime area where there'd been a recent shooting. They put all of that into the record, so it was apparent why they referred to it as a drug hotspot. 1 officer observed certain activities by Certain. The other officer observed different activities by Certain. They talked to each other, but they didn't fully share information, so each officer didn't know everything that the other officer knew. They approached Certain. They testified when they approached him, he was not under arrest, but was detained. They frisked him for officer safety. One of the officers felt a plastic sack that he had seen Certain stuff into his back pocket. The officer got that out. It field tested positive for contraband, and he was prosecuted for the drug violation. His lawyer argued that his client was detained, and the only thing that can be done during a lawful detention is a brief frisk of outer clothing for weapons, and that this was an illegal search and seizure because the officer's activities went beyond a frisk and were actually a search. When the Supreme Court got the case, they said each of these officers independently had enough information to have probable cause to arrest Certain for a drug violation. If you put together using the concept of collective knowledge all of the information both officers had, it was better than probable cause. A search instant to arrest can be done immediately before, during, or after the arrest. So this was, in fact, a search instant to arrest based on probable cause, and it was not an illegal search and seizure at all. And the court wasn't bound by the officer saying that Certain was simply detained, because they looked at all of the circumstances and found that the officers had probable cause and their actions were reasonable as a search instant to arrest immediately prior to the arrest.
So 3 things, and the good news about the computers this day and age, all you got to do probably say State versus Certain, Louisiana Supreme Court, zip, there's the case. On Chapter 2, the subchapter A, all we're giving you is like 4 or 5 lines about a case. The case may be 50 pages long. If you want to read a case, this is the case to read. It provides 3 different holdings that are really excellent for law enforcement. One, what has been the law now since 2006 in Louisiana, if you have PC to make an arrest for a crime that allows an arrest, you can conduct the search instant to the arrest, immediately before the arrest. Number 2, collective knowledge. Now, if you told me 10 years ago that Officer A could investigate a little bit about a guy tonight and tell some of it to Charlie, Officer Charlie, Officer B investigates about that guy tonight and tells just a little bit to Officer Charlie. Officer Charlie moves in and makes the arrest. The arrest of the subject can be legitimized, justified by every shred of information that any of the 3 officers had, even if all of it wasn't communicated to the officer who actually took the action. It's called collective knowledge, and it is an amazing tool for law enforcement. What it means is, if the arrest occurred at 3 a.m., what did each officer working that case know at precisely 3 a.m., even if they hadn't communicated to the officer who actually moved in and made the arrest? The other thing about this stuff is, you look at what the officers did objectively. These very truthful officers thought they were detaining and frisking. What they actually did was get evidence out. Sometimes, if the officers have enough knowledge, training, experience, maybe they got talented enough fingers to go bap, 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 and get plain field seizure and get the evidence out. I've been on the warpath saying that's a pretty weak way to ever get information out. We were teaching some of the narcos in Shreveport last year, and they said they've never had it challenged about a plain field seizure. So what do I know? But just know this, on the case here about these officers thinking they were detaining and frisking, the actual facts justified that what they had enough to make an arrest for a crime that allows an arrest. So however they got that evidence out, whether it's plain field seizure or whether it's as a search incident arrest, everything was good to go. Search warrants. Real quickly, you need to understand that facsimile application for warrants and electronic application for warrants are good to go. That's great. There's no question that they're legitimate. You see this case here on the next to the bottom line, it's on page 19, Missouri versus McNeely. Technically, that case was resolved against law enforcement, but realistically, what this case does is a great advantageous law enforcement case. Missouri versus McNeely, there's a DWI guy who was arrested, and the officer, he didn't have mandatory implied consent going for him, didn't have a warrant, didn't have consent, but he drove the guy to an emergency room and had blood drawn. Bottom line on this case was the U.S. Supreme Court said, I know that you had evidence in McNeely's body, and I know that evidence was rapidly dissipating, and so that's been an exception that's been used through the years when there's probable cause, but you didn't have time enough to get a warrant. And for instance, if the law enforcement officer in Shongaloo wants to get a search warrant from a district judge, they're going to have to drive down to Minden, then to Bossier City, and then back to Minden, and then up. But with facsimile application for warrants, electronic application for warrants, it takes out all the travel time that's involved there. On Missouri versus McNeely, what the Supreme Court said was, you got all kind of ways that you're going to be able to get that blood out lawfully, and one way is to secure a search warrant. He said most states have laws on the books, like Louisiana does now, that allows electronic application for warrants. So they said if it was so easy to get a search warrant, the officer should have got a search warrant. We're just not going to say that on a every case basis that a law enforcement officer has the right to automatically draw blood even if they don't have consent and don't have mandatory implied consent. The deal is this: if a person is operating a motor vehicle on a public highway, they've already agreed to blowing the machine, assuming you develop probable cause to make an arrest for DWI. They can pull back on that agreement unless there's death or serious bodily injury. If they pull back on that agreement, then there are going to be some administrative penalties that are going to come into effect immediately, and that's a real negative factor that the trial court can consider when the matter goes to trial. But unless there's death or, quote, serious bodily injury, unquote, you can't make the guy submit. Now, you can get a warrant. You can get a search warrant. Where do you want to search? The person of Joe Blow. For what? Blood for ethanol testing right there. Just know this. On serious bodily injury, normally there's 5 ways to prove it up, but for purpose of implied consent, you only have 4 ways. The factor about extreme pain doesn't exist. We've got about 10 minutes, so y'all stay with me here. You need to get you an I love me 2 or 3 paragraphs on your computer. If you apply for search warrants fairly regularly or every once in a blue moon, you need to go ahead and have you 2 or 3 paragraphs about how great your career's been and what all your accomplishments has been. I was shown a prototypical perfect search warrant affidavit by an FBI agent, and he started when he was in middle school and he was student council president. That's going too far. You're a 1999 graduate of Airline High School, spent 5 years in the United States military, 3 of it in the military police, went to the basic academy at the North Louisiana Criminal Justice Academy. In 2007, I got the I got the Marksmanship Award. I did this. I've been to these special schools. Whatever it is, you say, man, that's going to take some time. Yeah, it'll take 15 to 20 minutes once. Then every year on your birthday, you spend 60 seconds updating it. And when you go to do your affidavit in support of a search warrant, highlight, copy, and paste. That's the first 3 paragraphs of your search warrant. And what that affidavit does with those paragraphs in it, you're establishing credibility. Again, in Bossier Parish, your judges know who you are. At the Second Circuit, they may or may not, and they definitely don't know you down in the Supreme Court. Just saying, I've been a law officer for 11 years. That's great. Doing what? What have your duties been? So the more you can put in there, the better. It's not like you're in the Selectric typewriter generation like me, and you got to retype everything. You highlight it, you copy, and you paste it into your warrant. And you update it like annually. What has to be described with particularity, according to the 4th Amendment, on the search warrant, you've got to particularly describe what it is you're looking for and where it is you want to search. Back in the day, terrible things happened in the bad old days of search and seizure. If a line or 2 wasn't typed, we had to have a different description in the affidavit that's in the search warrant. That's a real problem. You only type it once. You highlight and copy and paste where you want to search, highlight, copy, and paste what it is that you're looking for. See at the bottom 2 lines right there? You know, in Louisiana, you can execute an arrest warrant at any time. You can't execute a search warrant at nighttime or on Sunday unless the warrant gives you that authority to do that. How is that accomplished? Well, it's pre-printed on your template. It's already there. It's not even something you think about. When the judge signs a search warrant, it's going to automatically say somewhere in there in fine print, you can execute this search warrant at nighttime or on Sundays. Here's another couple of lines you need to put in there. Just in case there's some confusion about what address it is you want to search. And if you just put 131 Church Street, Bossier, Louisiana, you're cruising for a bruising. You need to say head north on Highway 3, you take a right on Green Acres Drive. The second left will be Douglas Drive, and you'll see a greenhouse with white shutters and this, that, and the other, which is a municipal number, 251 Main Street. But if you're just using municipal numbers, it's just a matter of time because the post office can change the addresses, the 911 service district can change the addresses. There may be some situations come up, and if all you did was a municipal address number, there are going to be some problems. It needs to be very specifically described. If there's some kind of confusion, if you've got those 10 words on your search warrant, all it says is the affidavit in support of this search warrant is made a part of the search warrant. And it may help to ascertain, see, on a search warrant, it's an intrusion into somebody's privacy, and it's narrowly regulated by what the judge has approved. If there's some kind of glitch here or there, it's good to bootstrap the affidavit in along with the warrant. It'll help you to describe where it is you want to search. Before you go inside there, you got to get it straight. Who's going to be the 2 officers that are going to take every swinging person there? Going to take them out in the carport and watch them. Why are you going to, anybody that's there has to stay during the execution of the search warrant. Anybody that shows up during the execution of the search warrant, they got to stay there. What are the reasons for that? 1, officer safety. 2, maybe it'll facilitate the search. Maybe the guy that's there said, I know you got a search warrant. Don't tear up my bedroom. I'll show you where the stuff is. Or number 3, maybe some criminality will develop, and instead of having to chase the person down later, maybe he's right there and you can go ahead and do what you need to do. But you need to get a couple of officers to their assignment is going to be to whoever's there, zip them out into the carport so that 2 or 3 officers can actually do the searching without having to look over their shoulder. Before the actual searching starts, ought to be a quick protective sweep to make sure there's not somebody hiding there that could hurt the officers who are searching. All right, look at the big hole right here. If the three officers go in to actually look for the stuff that they're looking for, get it straight ahead of time, who's going to actually handle the evidence? A may see something, B may see something, but the deal is Officer C needs to be the one who takes possession and starts the chain. And if it's something that needs to be analyzed at the crime lab, Officer C needs to take the evidence to the crime lab. If the crime lab technician isn't the one to bring it back to court, the one who ought to go pick it up is Officer C. Then if you got a brand new 27-year-old assistant district attorney, he or she can prove up the chain in 5 minutes in front of a jury. On the return, what it needs to say is, what did you get? Heroin in the kitchen, who got it? Officer Charlie. What did you get? Marijuana in the living room, who got it? Officer Charlie. What did you get? Cocaine in the bedroom, who got it? Officer Charlie. And Charlie takes to the crime lab. We need to simplify things. Confusion in front of a jury inures quite strongly in favor of the defendant. And I've been there when officers said, well, I think I got the cocaine in the kitchen. The next officer said, no, I got the cocaine and I got it in the living room. But no, he got something else. The simpler that we can do this kind of stuff, the simpler the stuff can be proven in court. Bottom line, if you have on this stuff about 108 resisting an officer, know this, it's been expanded. Most of the changes have been since 06. There hadn't been a whole lot of cases interpreting it. But on on resisting an officer under 108, it applies to 4 situations. Are you making a lawful arrest? Are you making a lawful detention? Are you seizing property? Or are you executing any other order of the court? The second cut is, what are people prohibited from doing if you're engaged in one of those 4 activities? Nobody can interfere with you, resist you, obstruct you, or oppose you. If somebody is lawfully detained, they're going to have to identify themselves to you. Now, if you just say somebody on the street corner, hey, man, what's your name? You can say that. You can ask to see some identification. You can try to start a conversation. But there's no sanction against somebody if you just say, hey, man, who are you? If he says, I don't have time right now, police, that's the end of it. But if this person is lawfully detained, he's got to identify himself. And the reason for that is the U.S. Supreme Court said that's an officer safety issue. If you're dealing with Son of Sam, you're going to behave differently if you're dealing with Elmer Fudd. So if somebody is in fact lawfully detained, yes, he has to identify himself. We're going to stay here until the last dog dies. Just know this.
No, we're not.
Well, we'll stay here a few minutes. If anybody's got any questions, remember this, you can automatically get them out of the motor vehicle under those 3 cases there. It includes not just the driver, but everybody in the motor vehicle. But you cannot frisk them unless you develop individual, particularized, reasonable suspicion of danger relative to the person that you're going to frisk. This is Gene Drew. I'm Harmon Drew. This class was the courtesy of the North Louisiana Criminal Justice Academy up here in North Bossier Parish. Be safe. Thank y'all very much.
Thank you.
Appreciate it.